many thanks, Mr. Wolfson, for sharing with us these key insights from the EDPB and for presenting to us some of the key recent initiatives taken by the EDPB to foster cooperation towards more effective enforcement of the GDPR. It is now time to move from one EDPB commissioner to another. After hearing the voice of the EDPB, we will hear a keynote by a national data protection authority, actually probably by one of the most active data protection authorities in the world since the very early days of data protection. Here again, I am certain that our speaker is well known to all of you, so please join me in welcoming on stage Ms. Marie-Laure Denis, President since 2019 of the Commission nationale de l'informatique et des libertés, the CNIL. Ms. Denis, please join us on stage, and the floor is yours.
Ladies and gentlemen, dear colleagues and friends, good morning, everyone. Let me first thank Wojciech and the EDPS team for the organization of this conference. After 2 years of pandemic, we all realize how precious it is to meet in person again, to stay in touch and exchange directly. And for sure, when it comes to effective enforcement in the digital world, we have a lot to talk about. Since yesterday, we have heard valuable and different voices from civil society, academics, and other stakeholders. Let's face it, we have also heard some criticism, and we should certainly not turn a blind eye to them. To continue our discussion today, maybe one thing I would like to start with before addressing critics is where we are coming from and the initial objectives of the GDPR. The GDPR was presented 10 years ago and later on negotiated among the co-legislators with one key objective: to build a stronger and more coherent data protection framework in the EU, backed by strong enforcement that will allow the digital economy to develop across the internal market, put individuals in control of their own data, and reinforce legal and practical certainty for economic operators and public authorities. In other words, ensuring harmonization through increased cooperation to ensure a uniform protection of their fundamental rights for data subjects and legal certainty for all stakeholders. I still believe that this objective should be our compass for the future, and that we should probably start by taking stock of the improvements brought by the GDPR. For the data subjects first, the GDPR has brought the possibility to file a complaint to its own data protection authority and to have its complaint solved wherever the controller is in the European Economic Area. This is a major improvement for thousands of complainants throughout Europe whose complaints are handled and solved, including through our cooperation and consistency mechanisms. One key indicator in this regard, we have seen that individuals have increasingly made use of their rights. Complaints received by the CNIL have almost doubled between 2016 and 2019, going from 7,700 annual referrals to around 14,000 complaints, and we have remained at such a level since. These are significant numbers, also considering our current resources, and it shows how the GDPR has concretely empowered individuals in making use of their rights. For data controllers, the GDPR has provided them with a single data protection legal framework and a single interlocutor. Let's recall that this is an attractive mechanism and a powerful incentive. We have all seen companies organizing themselves to set up their main establishments in the EU to be able to benefit from this one-stop shop. The GDPR has also been designed to provide a stable legal framework, legal certainty being key for data controllers. In this regard, an important part of our collective effort has therefore been to develop various guidelines on key concepts such as the notion of legal basis, as well as on new technologies such as connected vehicle, for instance. Collectively, EU data protection authorities have adopted no less than 57 guidelines and 6 recommendations in 4 years, and they produce concrete effects. For data protection authorities, our cooperation and consistency mechanism one-stop shop was in itself a real challenge, given its novelty. Today, we can say that we made it. This mechanism is now operational and working. More than 2,000 cross-border cases and almost 1,000 cooperation procedures on cross-border cases have been implemented at EU level between 2018 and 2021, following which 354 final decisions have been adopted. Our enforcement efforts have also intensified, with cumulative fines by EU DPAs amounting to 1.55 billion euros by the end of 2021. Concretely, it has become our day-to-day practice to exchange with our EU counterparts. We have set up teams, specialized some of our staff, developed a network of colleagues within the DPAs. Within the CNIL, we have made the choice to expand our international and European affairs department, as well as to ensuring coordination on international and EU-related matters. And our enforcement department has also developed an expertise in the field of cross-border cooperation, in particular by participating in investigation with our counterparts in the Netherlands or in Luxembourg, for example. In our view, to be solid and efficient, this cooperation has to rely on mutual trust and common goals. We need to develop a common culture, and to achieve this, we need to develop interpersonal relations, and this is what the EDPB is also about, building efficient networks and communication. Over the past 2 years, the COVID-19 pandemic affected us collectively and individually, just like anybody else. But nevertheless, we have coordinated on major issues and adopted common positions, including on enforcement actions. To name but a few, we led the coordination on the so-called 101 complaints from NOYB concerning the use of Google Analytics tools and the transfers operated under this framework. We also issued our first decision following the urgency procedure provided by the GDPR and a second binding decision under the dispute resolution procedure of Article 65 GDPR concerning, as you know, processing activities of a major actor's WhatsApp. Let me stress also that one of the strengths of the GDPR is that it provides for the possibility to complement and adjust the practice on several aspects. It allows us to remain agile by entrusting the EDPB with different ways of complementing and clarifying the rules, including in terms of procedures. The GDPR has also been shaped with margins of flexibility to allow the EDPB and its members to complement and adjust the application of this text to the practice. And let's then recall that the GDPR comprises the flexibility necessary to also complement the channels of cooperation. So, where are we now? And what challenges have to be addressed? We are all gathered today to discuss the future of data protection and how to ensure an effective enforcement in the digital world. And in this regard, we should also be realistic about the remaining challenges to be addressed. Let's be clear. We do not consider status quo as an option, and we are fully aware of the margins for progress and the obstacles that we still have to overcome, including to ensure optimal cooperation. We also hear the criticisms and expectations that are sometimes becoming more pressing, especially regarding decisions on major digital players. Within the EDPB, we are collectively aware of these expectations and challenges, and we want to respond to them quickly and effectively. This is one of the priorities for the CNIL. The CNIL remains fully committed to keep contributing to the work and efforts of the EDPB. We even contribute in triggering the dispute resolution mechanisms. In this regard, we have two Article 65 procedures in progress, one to clarify jurisdictional issues and the other one on proportionality of sanctions. And this gives me the occasion to stress on one message when it comes to cooperation. The use of these emergency or dispute resolution procedures should not be seen as a failure of cooperation, but as a way to move forward and create jurisprudence. As I did for the improvement brought by the GDPR, I would like now to move on to what we can do and how we can improve things in the near future. From the data subject's perspective, I want to mention a recent study carried out by the CNIL Digital Innovation Laboratory. We looked from a sociological point of view at who the people filing complaints to the CNIL are. And some of the study results revealed a specific profile of individuals addressing the CNIL. This survey shows that men, senior executives, and people with a master's degree or higher are overrepresented. This has to change. We need to increase our effort in awareness raising, but also more generally in digital education. Regarding now data controllers, we should certainly keep on developing further guidance to ensure legal certainty and practical tools. And now from the DPA's perspective, how can we improve cooperation and enforcement? As already recalled, including by Aleid a few minutes ago, all heads of EU DPAs have gathered in Vienna a few weeks ago to work on a common strategy to improve our cooperation at the European level and to ensure concrete progresses are made in the months or years to come. Once again, this is a priority and a necessity for the entire European collective. At EU level, we want to prioritize cases of strategic importance, and this will most probably, but not only, concern big tech companies. We need to concentrate our collective efforts on cases which fulfill a number of quantitative and qualitative criteria, such as cases affecting a large number of data subjects in the EU, cases dealing with a structural or recurring problem in several member states, or cases related to the intersection of data protection with other legal fields. We have already started implementing the action listed in our statement. Strategic cases are being selected, and hopefully by this summer, we will launch pilot procedures to test how to accompany and ease the formal cooperation process through increased and closer work of DPAs on these prioritized cases. Once these strategic cases are identified under the direction of the lead supervisory authority, an action plan will be established at EDPB level to ensure that the work will be conducted in the most efficient manner and this is very important, within a fixed timeline. This is one of the commitments we have made in order to ensure swift enforcement, including towards big tech companies. The CNIL will take its part in the collective effort in this respect. Enforcement towards big tech companies is indeed one of the main critics we hear frequently. To be clear, these companies are on our radar, and several procedures are currently ongoing also at national level, which of course I cannot comment in details now. On top of the elements already mentioned, two other things seem to me important in order to make the GDPR more effective. First, we need to further intensify our cooperation among EU DPAs, and I will say, to use the famous term in EU law, sincere cooperation, and to ensure optimal exchange of information among ourselves to be able to act swiftly and effectively. Second, we have also committed to identify the list of procedural aspects that could be further harmonized in EU law to maximize the positive impact of GDPR cooperation. Harmonized horizontal provisions in administrative procedural law could bridge differences in the DPA's conduct of cross-border proceedings to increase efficiency. I'm pleased to hear that the European Commission has also identified this issue and is willing to address it, as declared by Vera Jourova yesterday. We are supportive of such initiative and are willing to contribute to this process. We have also decided to collectively undertake several other priority actions. DPAs will place particular emphasis on early and sustained sharing of all relevant information. The EDPB will facilitate the use of all instruments provided for in the GDPR, including Article 62 joint investigations. We also need to streamline and make full use of Article 65 dispute resolution mechanism and Article 66 urgency procedures by DPAs. We also heard calls for more centralized enforcement mechanisms, and I would like to say a few words about it today. First, it has to be said that the one-stop-shop mechanism is already partly centralized. It is certainly unique, and it could be described as an integrated decentralization. All national authorities have competence on their territory, but they decide collectively on cross-border cases with a single EU bodies for dispute resolution and ultimately a single decision at EU level through the EDPB. An important element to keep in mind on our discussions is that, contrary to other regulatory fields, we are not regulating market conditions, but protecting a fundamental right enshrined in our primary law. Our model is unique also because it has to meet two essential criteria: allow each individual to file a complaint to its national authority, regardless of the company concerned in Europe or beyond, ensure it's in compliance with the Charter and the treaties that enforcement of data protection rules is the responsibility of independent authorities, a competence which cannot be devolved to the executive branch at national or EU level. Let's also recall that the competition enforcement model, often taken as an example, has significatively evolved over the years. It started in the late 60s with a fully centralized enforcement mechanism by the European Commission, which did not prove fully efficient, and national competition authorities have progressively been integrated in the mechanisms over the years. The adoption of the Digital Markets Act illustrates a trend for a new centralization phase, but national competition authorities remain involved in the process. Furthermore, we should remind that it took several, if not many, years before the big competition decisions were adopted. There's always a learning curve when you set up new enforcement models, but it's true that when it comes to digital ecosystem and its rapid evolutions, we cannot afford waiting several years, and we need to act now. And that's why we have collectively decided to act, building upon our current model to deliver more swiftly, address our current challenges, and meet our common objectives. Finally, and this is not completely in our hands as DPAs, let's recall that the GDPR places an obligation of member states to provide their national authorities with sufficient resources to carry out their duties. It's not only a question of numbers of staff and budget, it's about meeting our ambitions for the regulation of the digital ecosystem. For several years now, the CNIL has seen its resources increasing, and we are on the right trend, but it needs to be amplified given the many challenges ahead. And this is certainly true for all EU DPAs. We also count on the European Commission to ensure all member states comply with their obligation in this regard. To conclude, if you allow me, I would like to highlight 4 lessons I believe can be drawn more generally from these 4 years of GDPR. Without minimizing our current challenges, the first lesson may be that we should not be shy in our attempts to regulate the digital ecosystem. Some critics said at the time of the adoption of the GDPR that it would never work and that personal data processing would no longer be possible in the EU. They were wrong, and instead, the GDPR has become a global standard for personal data protection. The second lesson is that we should probably be more proactive in explaining and promoting the GDPR towards companies, including SMEs, as a competitive tool which can become a competition distinctive advantage. Data protection and privacy are becoming a grower consuming demands, even at international level, and we need to make further use of this leverage. The third lesson is that our digital environment is evolving rapidly and that we need to react more swiftly in order to be able to address effectively certain practices and data processing before they become de facto reality. This is what we aim to achieve with our renewed commitment and priority actions among EU DPAs. The fourth lesson is that data protection regulation alone will not address all challenges currently facing our digital economy and societies. We need a comprehensive approach, and that's what the EU has been promoting with new regulatory frameworks such as DGA, DSA, DMA, Data Act, and the AI regulation. But we need to keep in mind that our regulatory framework needs to remain coherent and understandable for individuals and for companies. It is therefore essential to ensure coherence and that we work further on governance for an optimal regulatory cooperation across different regulatory fields, as already mentioned yesterday by Margrethe Vestager. I believe that we should seize this unique opportunity of this conference to exchange views while keeping in mind these elements and always aiming at our initial objectives. The future of data protection has always been to make it a concrete reality for individuals as a fundamental right. And maybe today, more than ever, we have a duty to succeed collectively, not only as a regulatory or policy objective, but also for the promotion and preservation of our common values. Thank you very much.